Justice Ketanji Brown Jackson made a shocking statement during oral arguments today, essentially backing rogue judges blocking Trump's agenda nationwide. But before we explain the story, please like, comment, and share at Explain America. It helps us get common sense journalism out to the American people. Now, the Trump administration is fighting to rein in the abuse of nationwide injunctions. One rogue judge in one district can block lawful executive actions across all 50 states. It's a fight about checks, balances, and the Constitution. But Justice Ketanji Brown Jackson, she doesn't just defend the practice of nationwide injunctions, she basically argues it should happen more often. Let's be clear about what she's saying. One unelected judge can stop the elected president from implementing a national policy, even if that judge ends up being wrong. This is just mind-boggling. Listen.
Let me just turn your attention to one other thing, because the real concern, I think, is that your argument seems to turn our justice system, in my view at least, into a catch-me-if-you-can kind of regime from the standpoint of the executive, where everybody has to have a lawyer and file a lawsuit in order for the government to stop violating people's rights. Justice Kagan says, let's assume, for the purpose of this, that you're wrong about the merits, that the government is not allowed to do this under the Constitution, and yet it seems to me that your argument says we get to keep on doing it until everyone who is potentially harmed by it figures out how to file a lawsuit, hire a lawyer, etc. And I don't understand how that is remotely consistent with the rule of law. You know, a system, and I appreciate that you go back to English common law and the Chancery Court, but they had a different system. The fact that courts back in English Chancery couldn't enjoin the king, I think, is not analogous or indicative of what courts can do in our system, where the king, quote unquote, the executive, is supposed to be bound by the law. And the court has the power to say what the law is. And so one would think that the court could say, this conduct is unlawful and you have to stop doing it.
I think the catch-me-if-you-can problem operates in the opposite direction, where we have the government racing from jurisdiction to jurisdiction, having to sort of clear the table in order to implement a new policy. A great example of this is in the Schilling litigation, where the military had a military readiness policy. It was universally enjoined by the DDC. It went up to the DC Circuit. The DC Circuit stayed that injunction to allow that policy to go into effect, and then 1 hour later, a district court on the other side of the country universally.
Can I just ask you one final thing, because this relates to also something that Justice Kagan said. I would think we'd want the system to move as quickly as possible to reach the merits of the issue and maybe have this court decide whether or not the government is entitled to do this under the law. Wouldn't having universal injunctions actually facilitate that? It seems to me that when the government is completely enjoined from doing the thing it wants to do, it moves quickly to appeal that, to get it to the Supreme Court, and that's actually what we would want. What I worry about is similar to what Justice Kagan points out, is that if the government is saying no lower court can completely enjoin it, it actually means that the government just keeps on doing the purportedly unlawful thing, and it delays the ability for this court to reach the underlying issue.
Percolation of novel, sensitive constitutional issues is a merit of our system. It is not a bad feature of the system.
The Trump administration gets it. The system is designed to test laws through multiple cases, different jurisdictions, not having one judge play king or queen for the entire country. Justice Jackson's logic: delay the executive, empower the judiciary, and turn the Supreme Court into the final referee on politics, not just the law. This isn't just reckless, it's unconstitutional, and it's dangerous. Let's paraphrase what she's really saying. We want to be the ultimate political power in America. Let the courts rule the country. That's not what our founders intended. That's not what the Constitution allows. And it's not what she swore an oath to uphold. She took an oath to faithfully and impartially uphold the Constitution, not to rubber stamp activist judges or turn the judiciary into the ruling class. But once again, we're reminded, for the modern left, the ends justify the means. Rule of law? Optional. Separation of powers? inconvenient. The only thing that matters is power and who gets to wield it. This has been Kyle Becker for Explain America.